Gandang hapon. Good afternoon, everyone. We're actually doing two hearings today for two bills. This is for the PTRO first. Now, this bill actually passed on third reading already previously. So we just like to get comments again. This also passed already in Congress, actually. So we'd like to get quick comments from DFA and from DTI as well regarding this bill. And then later on, we'll go to the Corp Code amendments. No? I'd like to thank everyone for coming to this hearing. We're actually the last hearing of the year, I think, for for the Senate. But we thought we'd maximize the time to be able to consider some of these bills. And hopefully, if there aren't a lot of opposition, we can already push for the passage of these bills next year. Okay. So for the PTRO, we have three bills. SB 1084, which was filed by Senator Gingona, SB 1149 by Senator Trillanes, and SB 1404 by Senator Estrada. So we'd like to solicit some comments. Maybe we'll begin with the DFA. Mr. Punsalang, for your official comments on these bills.
Yes, Mr. Chair. We will submit our written comments on this, because unfortunately, December being an APEC, with all the APEC meetings, certain key individuals weren't around to consult. But all the three bills actually are very similar in intent. Just certain provisions.
How about, in general, first, Mr. Punsalang, regarding setting up this office?
Well, sir, we will put that in our comments, because this contains certain legal ramifications.
I see.
And even sensitivities. So, for the record, we would like to put it in writing para sigurado ho.
Okay.
But, well, if you go through it item by item, and if there's something that concerns the FA, I can make a comment, sir.
Yeah. Well, I think primarily in other countries, this function is actually lodged with the Foreign Affairs Group, if I'm not mistaken.
Yes, sir.
Here, it's actually lodged with the DTI.
Yes, sir.
But I think the bills actually wanted to be an Office of the President function, no?
Yes, sir.
Maybe quickly, Mr. Punsalang, you can give us an overview on how currently the system is with regard to trade matters and the DFA. Because when I go to other countries, usually it's the embassy who meets me, but there's a DTI person who's also there, no? From the trade attaché, the commercial attaché, and they work very closely with the embassies, no? So baka you could give us then I'll ask DTI also to give a comment, no? How does it work now with regard to promoting trade in the rest of the world?
Well, sir, for speaking for DFA, we have as one of our pillars, three pillars, economic security, the other being national security and assistance to nationals. So under economic security, our main thrust is economic diplomacy. And we do that with all our foreign service posts under the one country team approach. And I think DTI has trade representatives or attachés in about 35 foreign service posts. And where they have trade attachés, they normally take the lead in terms of generating trade, investment, leads. But also the DFA, because we also have our own mandate, we also cooperate with them in terms of sharing information and leads. Now, in the rest of the other countries, there are about 84, 85 foreign service posts where there are no DTI trade representatives. Then we have an economic diplomacy officer. Their job is actually to collect economic intelligence, to include also business leads, also policies which the host government might make, which might impact on our country and our economy. Then we feed this information to our home office, who in turn also contact DTI. But sometimes DTI, they already provide us with information like trade directories, which they vet, and with that in mind, we can already start connecting interested queries with businessmen or interested parties here. That also we coordinate, we attend interagency meetings with regards to trade policy, usually chaired by DTI, or if it's economic development, chaired by NEDA, because NEDA has the overall responsibility for developing a socio-economic plan for development. But once here in the home office, DTI has the lead. We have an office in DFA. It's called the Office of the Undersecretary for International Economic Relations. It's principally divided into two. One is right now handling APEC. It's called the APEC National Operations Committee, I think. It's like a secretariat. And one is concerned with economic diplomacy, which is the promotion of trade, investment, and tourism abroad.
How does the interface happen in embassies abroad? Do the trade attachés hold office also in the embassies? In the 35, sige, Director
Yes.
Katibayan, would you like to share your...
Sir, it's not uniform. It's not across the board. Where there's space and the embassy has space that can accommodate the commercial attaché, then we try to use that space. In some countries, however, the commercial office is separate from the embassy. But we closely work with each other with respect to trade matters.
With regard to accountabilities, they're still accountable to DTI, not to DFA.
Yes, the commercial attachés are under the supervision of the DTI.
And specifically, Yusek Manalo, right, is handling that? Or Yusek Cristobal?
Dalawa, sir, no? We have a promotions group and a policy group. For posts that are basically handling promotion, si Yusek Chito Manalo. For posts that handle policy, for example, the Washington Post, Geneva, Brussels, Jakarta as well. Si Yusek Che Cristobal, sir.
Okay, so on the ground, for 35 countries, out of how many countries are we in? So 35 out of 84, these are identified as our high potential for trade. So DTI has manpower there. They may or may not be in the embassy, depending on the situation. They work closely with the ambassadors and the ministers, but at the end of the day, they still report back to head office. Yeah. Okay. Director Katibay, would you like to give a comment regarding this? I know you're not too keen on this, no? Was DTI keen on these bills? Parang you're not, right? Sige, go ahead.
Sir, first, I understand that Yusek Che Cristobal wants to attend, and I think he'll try to catch up. He's just with Secretary Domingo. And excuse my hoarse voice, sir. I'll just...
Masyadong na Christmas party. Yeah, naubos. Sige, go ahead, sir.
Sir, we have an 8-page paper, but I'll just, if you'll allow me, I'll just read the highlights of it para I don't take the time of the committee too long. No? So, as an introduction, there are 3 bills. The first one envisions to improve and strengthen the negotiating capability of the Philippines. The second one formulates cross-trade strategy that is cohesive with our development goals. And the third one attempts to enhance international trade policy formulation and negotiations, noting that the present setup shows an overlapping of functions and responsibilities. Said bills also seek to address the stakeholders' needs and the right of the people to participate in economic decision-making. The DTI perspective, sir, is we believe that the existing Philippine trade policy-making structure and trade negotiation mechanism addresses the trade policy formulation and trade negotiation concerns, such that the creation of a Philippine Trade Representative Office is not necessary. In the Philippines, trade policy making involves a unified interagency process that ensures a clear link and integration between domestic policies and international positions. B is coordinated across different organizational levels, both technical and cabinet level, by an established interagency mechanism. And C is led by the DTI during international negotiations. Following, sir, are our specific comments. One, at the domestic level, there is a government body that coordinates and clears Philippine trade negotiating positions. Through the Committee on Tariff and Related Matters, trade negotiating positions are deliberated among relevant agencies at the technical level and are eventually elevated and discussed at the cabinet level and decided on by the President. Under Executive Order 230, which reorganized the National Economic and Development Authority, the NEDA board, chaired by the President, is responsible for formulating, continuing, coordinated, and fully integrated social and economic policies, plans, and programs for the Philippines. It has 7 cabinet-level interagency committees, including the Committee on Tariff-Related Matters. The CTRM is mandated to advise the President and the NEDA board on tariff and related matters and on the effects on the country of various international developments, coordinate agency positions and recommend national positions for international economic negotiations, and recommend to the President a continuous rationalization program for the country's tariff structure. The CTRM is chaired by DTI Secretary and co-chaired by NEDA. Its members include the Executive Secretary, Secretaries of Foreign Affairs, Agriculture, Transportation and Communications, Environment and Natural Resources, Budget and Management, and Finance, and also the government of Bangko Sentral and the Tariff Commission. The CTRM, sir, follows a 3-tiered structure: the cabinet level, and then technical committees, the subcommittee level. These 2 committees are the TRM Technical Committee and the Technical Committee on WTO related matters. The Technical Committee is co-chaired by the DTI Undersecretary and NEDA Deputy Director General. And Secretariat support is provided by the Trade, Services, and Industries staff of NEDA. The Technical Committee on WTO-related matters was created upon the endorsement of the NEDA board. Its main task is to discuss and recommend national positions or strategies on issues directly relevant to the implementation of our commitments as a member of the WTO. At the international level, there is a government agency that leads and coordinates trade negotiations. However, sir, sectoral negotiations are led by sectoral line agencies that actually have the mandate over issues being discussed. This ensures that during actual negotiations, Philippine positions are aligned with domestic policy. DTI was conferred the trade policy mandate as stipulated under EO 133, which reorganized the Department of Trade and Industry. This was continued under the DTI Rationalization Plan, which was approved October 17 last year. DTI, through the Bureau of International Trade Relations, has developed the expertise in trade negotiations and in forging trade agreements with other countries. It leads and coordinates the country's trade negotiations. Sectoral negotiations, however, are led by the concerned line agencies that have the mandate over sector-specific issues being discussed. The Philippines has a decentralized model for trade policy making where mandate is dispersed across sectoral agencies. Philippine trade policy making process and negotiating mechanisms can be described more accurately as vertically integrated and horizontally decentralized. That is, trade policy making is undertaken across agencies, but there is a clear link between domestic policies and international positions. The overall logic behind this structure is that trade policy formulation and negotiation should be assigned to those who have the sectoral mandate. DTI has the most extensive overview of these functions. Locating the trade policy function in a separate office would require extensive measures to compensate for the loss of its natural setting and would expectedly disrupt the requisite balance of trade policy vis-a-vis policies relating to industry and investment, including those that are relevant to address the needs of micro, small, and medium enterprises. Moreover, international trade issues affect domestic trade affairs. These two are interdependent with each other. Hence, policies affecting one must take into consideration that of the other. Our third point is that stakeholders participate both in the domestic policy-making process and in consultations undertaken for specific negotiations. The government since 2011 has intensified public consultations. In May 2011, DTI launched a unified framework towards an integrated industry and trade strategy. The approach rests on three pillars. These are one country, one voice, which institutionalizes stakeholder engagement in trade policy making, one country, one network, which strengthens the trade policy research network and capacity building, and then one country, one team, which enhances interagency coordination and cooperation. These pillars are supported by advocacy and communications initiatives and projects such as doing business in free trade areas. Underpinning the entire framework is industry competitiveness, aligned with trade policy and trade negotiation positions. We have a few more. Konti na lang, sir. Finally, we wish to point out that the country's trade policy making would benefit much if it is given the flexibility required to pursue the country's national interests in trade negotiations, especially if what is being pursued at the minimum is designed to promote economic efficiency. In conclusion, sir, the Department reaffirms its position that the creation of a Philippine Trade Representative Office is not necessary, given the existing Philippine trade policy-making structure and trade negotiation mechanism. The creation of a wholly separate cabinet-level agency dedicated solely to international trade negotiations may not be the most practical and feasible option, considering the plethora of concerns and issues besetting our government and people. Creating another agency with the same functions as an existing institution would create redundancy in powers and a layer of bureaucracy, thus leading to inefficiency.
Thank you, Director Katibayan. Well, I think the main reason why these bills were filed is because perennially the comment is always mababa yung FDI natin, di ba? Our foreign direct investment is not as high as our neighbors. It's it doesn't match the fact that we have the best performing economy right now in the ASEAN. Pero yung FDI natin is really much lower than our neighbors, no? Now, I think I can probably surmise that the reason why my colleagues filed these bills is because they wanted to see that extra push pagdating sa FDI natin. So are you of the mindset that even putting up a separate office will not necessarily increase the FDI or support our FDI goals and objectives?
Yes, sir, but actually, we've taken note of the many views expressed by different stakeholders arising from previous trade negotiations, and we've corrected many of the shortcomings that we've experienced. And through the three pillars that I mentioned earlier, it is our view that we have that this approach addresses the issues related to the criticisms of our approach towards FTA negotiations.
So in short, we agree on the problem, but this may not be the solution. That's it, no?
Your Honor.
Okay. If we were to enhance the current offices of DTI, for example, to reach the goals that are the goals which probably created these bills, no, or the goals behind these bills, what would we need to do to be able to increase our FDI, be able to improve our trade relations with other countries? If it were to be within the mandate of DTI, for example, what changes would need to happen?
Within DTI, sir, we have actually started the process with the rationalization plan. We have reorganized the Board of Investments, and that is a continuing process, sir. We have instituted certain programs within the investment function, investment promotion function, which would we expect to generate additional investments in critical areas. For example, we have the manufacturing resurgence program, and it has actually borne fruit because the share of manufacturing for the last 3 years to total GDP has increased substantially. The other point on free trade negotiation, we are expanding the Bureau of International Trade Relations from a staff of less than 20. It will grow to around 50. And many of these people that we will hire will be handling trade negotiations, the upcoming trade negotiations on Regional Comprehensive Economic Partnership Agreement. This is ASEAN with so many countries, the Trans-Pacific Partnership, APEC, Yusa Cristobal just came from Europe negotiating with the EFTA, and then we have this RP-EU scoping agreement. So all of, in effect, what we're saying is that we are already preparing ourselves to handle more FTA negotiations and build capacities.
All right, thank you. Thank you, Director Katibayan. We also have here the position paper of the Joint Foreign Chambers, and they're quite supportive of the bill. Let me ask now Mr. Chua from MBC if they have a position paper or if they would like to state their position for the record.
Thank you, sir. Right now, we don't have yet a position paper because we would also like to take this opportunity to hear from our government friends who would be at the forefront of trade negotiations. But at least MBC supports trade and investment facilitation. We agree with the intent to rationalize or at least have a dedicated office for these trade functionalities, especially when the present setup really has some complexities and overlapping functions. However, the current practices are working but somehow needs further streamlining and probably staff and technical support. So taking from the line of question you had earlier with Director Katibayan, it may not be, or if it does, I'm not sure if this PTRO will be the answer to it, because even from the description of the DFA, there seems to be a mechanism in place, and it seems to work. Putting another layer may not be clear. So long as this PTRO will make it clear that the functions and then the right people for that matter will be assigned to that. For example, if the present team from BITR, from DA, will be the one comprising that PTRO, because for sure they are the ones who's already immersed with the situation, who've been working on the negotiations. So if they will be the one who will comprise this office, then it may work. But literally transferring them into an office may not be that practical. Also, we have a competition policy, which we commend the good senator for having it passed in the Senate. I am wondering how this Fair Competition Commission, especially it also has aspects of trade issues, how this complements or run counter the functions and it as an organization with the PTRO if it will be set up. We also recognize that the DTI has been strengthening its offices. Particularly, we note the revitalized investment assistance service that they have, the coordination they have with the Office for Investment Ombudsman. So this present initiatives, how will this interplay with the current functions and office of the PTRO, especially that FCC, once this will be set up? So,
yeah, thank you, Mr. Chua. Actually, with regard to the possible or hopefully possible FCC creation, it won't really come into much conflict because this is really a matter of trade facilitation and trade promotion more than anything else. So, ang direct hit talaga nito is really DTI, no, because they're doing the functions. And the bills are basically supporting the move to create a whole other office, not even under the DTI Secretary, but under the Office of the President, which does those functions. So, yun talaga, I think that's the crux of the issue, no, more than the functions itself, no. In fact, maybe Dr. Katibayan, in your position paper, you can also state if the functions stated in the bills are already the functions being done by the 2 or 3 offices that you mentioned under DTI. I would think that it's very similar, no? Yeah. It's overlapping. So parang kina-carve out niya yon and putting it into another office. Yeah. Anyway, thank you for that, Mr. Chua. So we have from the Joint Foreign Chambers. We'll wait for that position paper, no, Mr. Chua. I don't know if the other agencies would like to give comments on this. Yes, sir. Mr. Yusek Serrano, please.
Thank you, Mr. Chairman. We have supported this bill from the very start, I think until about the last Congress. And this primarily based on our experience and our consultations with our stakeholders. I personally manned the negotiations, Mr. Senator, since 1998. And I think there's a lot of confusion between trade policy and trade negotiations, as well as between the negotiating effort and the implementation of what you obtain as concessions in those negotiations. There is a saying that the military unit that conquers territory cannot administer the territory, because that way you generate a lot of confusion and more inefficiencies. From our experience, what we would want for this to evolve is a dedicated unit of trade negotiators. It cannot be big, but it is one that would develop a dedicated negotiating functions for the country, whether it's trade, investment, and so on. Yung po mga trade negotiators natin, Mr. Senator, katulad po ako, wala man po ito sa performance contract, wala to po sa workload. We are, in the terms of our secretary, we are missionary negotiators. We do a lot of other things. I do policy and planning, research and development, project development, and regulatory services. The people I face on the negotiating table do only this from the time they join their bureaucracies. They only do trade negotiations, trade research, and this is what they input their trade policy people. So it's very important na set yung trade policy natin, iba yung gumagawa niya, kabinete po yan. Pwedeng yan yung CTRM. Pero when you have various decentralized negotiating, my experience is like say in the WTO. We negotiate, for example, agriculture, and we also take care of fisheries. NEDA does services. DTI does NAMA, non-ag market access. So pag nagkaroon ng agreement doon sa various areas na yon, ang malaking problema po natin yung horizontal natin internally. So how do you, wala tayo dito sa atin, yung rebalancing. Usually after an agreement in all of this, you are given something like 6 months to rebalance. In my personal calculation and the way and the level of agility of our process, hindi ho natin kaya yun. No? Kailangan mo talaga dyan, meron kang dedicated na pwersa ng tao na you can deploy anywhere. And looking at the negotiating landscape, we want to do EU. We want to do EFTA. We're doing RCEP. We're implementing all of the other agreements. We're reviewing GPEPA. We want TPP. We have ambitions on TPP. The negotiating landscape, Mr. Senator, is massive. And with all due respect to my colleagues in the CTRM, the way we are configured, that does not give us the right combination of resources and agility to be able to pursue this. Ang kailangan ho natin dito, I've experienced negotiations and it's merciless. In these negotiations, there are no brother ASEAN, it's every country for itself. So we have to be very, very definite about what we want. And that takes a lot of negotiating resources, dedicated negotiating research, the development of negotiating institutions, which would include how they would coordinate. Ang importante ho kasi, hindi ba, sa giyera, meron kang backing ng political masters mo, na meron ka ring backing ng taong bayan. So, trabaho ho yun ng ano. Ang trabaho ho namin, halimbawa, sa Department of Agriculture, dapat, ito yung landscape sa agriculture. Ito yung kailangan. Yung pagbalansin niyan with the other sectors, industrials, meron ho dapat niyan na siguro yung CTRM, no? Pero yung pursuit ng negotiations, siguro po, ang sa amin yung design ng domestic support programs for agriculture. Pero dahil sa napupersa ang lahat, pati nga tariff commission na nasusubo na rin sa negotiations. Pag titignan mo, hindi naman sila dapat nandun sa negotiation. So, that's very important. Now, when you have the negotiating effort must also be differentiated from the implementation of trade agreements. Most of our people, when they are posted, the Department of Agriculture, Mr. Senator, has also agriculture attaches and counselors abroad that take care of our interests. But they have two distinct functions. One is monitoring of the implementation of our agreements, aside, of course, from economic intelligence. And the other one is dedicated trade negotiations. When we have two people, one in the WTO, for example, one does implementation issues, the other does the negotiations. Magkahiwalay ho yun. Pag pinagsama mo yun, magulo talaga eh. You can, hindi pwede yung nag-ano ka ng, halimbawa, ng anti-dumping pagkatapos you do negotiations. And it's negotiations is still a person-to-person effort. So, hindi ho pwedeng yung tao mo na gumagawa nito ay yun din ang ano. Ganun din po dito siguro sa capital. Kaya kung minsan ho nagkakaroon ng mga conflicts, no? Hindi ho kasi mabilis yung mechanism natin na mag-decide. Like, kung merong negotiation sa Geneva, kailangan mo ng desisyon ng mabilis. Kung aasa ka sa CTRM, hindi ho ganun kabilis. Or sa TCWM. Ang mangyayari niyan, aasa yan doon sa clearance sa secretary na amo nung negotiator mo doon. While that may be expeditious, that's not necessarily good because the balance might not take care of the balance so you might have certain negotiating decisions na medyo prejudicial sa ibang sectors. So it's important, just to reiterate, we need to be able to have a dedicated effort through PTRO or some other thing. But in fairness to my colleagues in the DTI, they have led under the current administration the coordination. But ang fear ko ho, pag nag-blow up na yung lahat ng negotiation, nagsabay-sabay yan, sa office ko po, wala nang matitira. All of them, one will be doing RCEP, one will be doing, and so on, no? So we need to be able to get this group of dedicated, very efficient negotiators who will develop the negotiating culture, develop the negotiating technology that is specific to the country and our interests. So, again, agility is very important. So once the trade policy is set, and you've given the mandate to negotiate for, say, RCEP, or you negotiate with EU, so yun bigyan mo na ng, ano na yung level ng flexibility ng negotiator mo. Bigyan mo siya ng negotiating objectives, yun lang ang gagawin niya. He doesn't have to worry about policy or anything else. Thank you po.
Thank you. Director Bernardino, would you want to give a comment or add to the discussion?
Thank you, Mr. Senator. The instructions given to me by our chairman is to support the position of TRM. Okay, TRM is because the TAR Commission is a member of the TRM, as mentioned earlier by Director Katibayan, and yes, being a member, then according to him, we will support the position of TRM.
All right, salamat po. Director Katibayan, would you like to respond to some of the concerns raised by Yusek Serrano?
Thank you, Your Honor. The reasons he cited about weaknesses in the trade negotiating aspect of what we're doing is that's the very purpose of expanding the Bureau of International Trade Relations. The BITR will grow 2.5 times. No? We are in the process of getting people who will do mainly trade negotiation. In fact, full-time negotiators sila. And then, they will have accounts. For example, people who will do RCEP, people who will do EU, PH.
But Director, with the current setup, yung agriculture is still with DA. Diba? And
Yes,
then
yes,
DTI is just handling the non-agri. And then NEDA is handling the services. Would the increased BITR also be able to support the agricultural attaches or the negotiators for the agricultural side?
Tamang-tama, sir, yung dating ng boss ko. nandito niya siya to answer the question.
You don't want to answer. He hasn't heard the question yet. Director Katibayan, pinapasa mo na. Of course, I'd like to acknowledge you, Sec Cristobal. Yeah, I think sige ako na magre-recap, Director. Pinasa mo kaagad eh. No, Yusek Serrano raised some concerns regarding how we do the current trade negotiations. Yusek Serrano, you may correct me if I'm wrong, but I think the issue right now is that pag agri, it's the DA that does it. Kapag services, NEDA does it, and then kapag non-agri, DTI does it. But the coordination among the three, in Yusek Serrano's experience, is not as good as it should be, which is why they were supporting the creation of a separate office which houses everyone, so that the trade research, the negotiation research, trade research can all be housed in one area. And then he also talked about their concern that once all these agreements start to come to fruition, na sila mismo, mauubusan na sila ng tao. No? So, and Director Katibayan mentioned that the BITR is expanding. So my question is, yes, it is expanding, but will it also include the negotiation for the agri sector, for the services sector, or just for the current DTI mandate?
Thank you, Senator. Well, of course, we work well with Yusek Serrano, and we respect his views. No, he's probably the most senior trade negotiator we have now. But from our observation, the issues that and concerns that we experience now, and we will probably continue to experience, no, because this is not a neat matter. Trade policy and negotiations, it's not neat. Stems from historical experience. So parang whatever office we try to create or structure, it's how we make the structure work. Now, in the past decade, my understanding is from a lot of meetings with the other agencies, is that we were new in this game. We were new in this game. Our only bilateral trade agreement is with Japan. That's our only bilateral. And our only experience is limited to ASEAN FTA negotiations. So when that reality struck the country more than a decade ago, there was really a gap in negotiators. We were not ready for that. Policy making, even coordination. So there's a lot of lessons from that time. So for instance, in interagency coordination, the bill recognizes that. There's a need to strengthen that. Over the past 3 years, we've really improved a lot compared to a decade ago. Now, formally, it's the, but Yusek Serrano can comment also if he agrees or not, but from what I've seen, the Committee on Trade-Related Matters under the NEDA board, which is chaired by the President, has finally evolved over the years into a relatively cohesive interagency body where we clear all our nego positions. I think that's not the way it was even as early as 5 years ago, 6 years. So it had to evolve into that body. There's a lot of questions first in the beginning. Is this really the mandate and all that? But after studying it well, it turns out that's really where all the country's international economic negotiations should be cleared.
You said which is this group again?
The Cabinet Committee on Trade, Tariff and Trade-related matters.
And that is headed by the President.
That's chaired by the DTI Secretary, co-chaired by NEDA,
Okay.
and it's under the NEDA board. So our positions are actually cleared at the cabinet level. So on structure-wise, admittedly, I think there was a problem with that in the past, no? But for the past 3 years, our program on one country, one team, I think we've been strengthening that. We've even had capacity building and training for the members. Now, on the agencies negotiating themselves, again, a decade ago, the Trade Department, the country as a matter of fact, was not ready for this. So, anong nangyari, those with the technical competence, DA on agriculture, for instance, were forced to negotiate the positions. Because at that time, DTI also, until now, could not even pretend to know the agricultural landscape, the issues, as well as DA. Or services, because of its broad scope, covering several agencies. The most neutral was NEDA, and coordinating with everyone as a planning agency. Transport, those other things that had to be negotiated on that side, that would be the OTC. So other agencies were forced to do that because we really lack people. And that's the situation we're still in now. The proposal we gave to the President a year and a half ago to beef up the BITR, and he approved the additional 50 people, is to reach that level that Yusek Saran was talking about, that we should really have a devoted team of negotiators, whether agri, services, and all that. Then the technical agencies provide the substantive, the technical inputs. But when it comes to negotiations, it's the Trade Department with its negotiators.
So the goal is for BITR to eventually
Yes.
handle the negotiations for all sectors.
Yes.
With the line agencies as the support for this.
As the technical
support. no?
Yes, that would be the ideal. And I noticed the proposal for a PTRO, just like the way the US does it, is there's really going to be an agri negotiator, a services
Right.
negotiator,
So,
and all that.
Tama ba, Yusek, na what you're trying to do sa BITR is very similar to the PTRO, except that BITR is under DTI and PTRO is a separate agency. But more or less, the
Yes.
goals and functions are the same.
Yes, on that note, Senator, we're not ready to say that the Trade Representative's Office of the U.S. or a few other countries is the best practice. We're not prepared to say that because not many countries even do that. In fact, at this stage, from our experience, we believe if we detach or separate or put too far away the negotiations and the policy making from the line agencies, we have a real risk of coming up with trade policy positions that are incongruent or even contradict your domestic policy. At this stage, at DTI, internally, we've separated policy and nego from our promotions, as you very well know. But it's still within the agency. So the market sense and supply side demands of the country, we align it with our trade policy positions. If you separate this too far, baka magano yun. There won't be a link, a proper coordination between the two.
Okay. Any other agencies want to give comments? Because if none, we're going to move to the Corporation Code bill. Anyone? Or from the floor? Sorry, from the plenary? Anyone? No one? Okay, sige. So we'd like to...
Sir, we need to suspend. Kasi sir, magkaibang committees. May ka-join tayong iba.
Okay, so we're going to suspend, just to put it on the record, no? We'll be suspending the hearing for the PTRO bills. We'll take into consideration all of the comments from the different agencies and feel free to submit to us the position papers. So we suspend that hearing. No?
So, ito sir yung pang PTRO.
We now call to order the, we'll allow people to leave first. Sige.
Sir, pahinga muna. Sir,
Oh, sige.
sir, mag-ano na lang tayo ulit. Tayo.
Finally. Okay, may we request our guests to take their seats? It's the same. Ayaw ba to? They're all the same. Hello, good afternoon, Merry Christmas. File ba ang version for us?
Ito ba?
Ayan. Parang mas maikli yung ating kay...
Yung exact copy lang.
So, varying ano pala to? Varying lengths.
That's easy yung presentation, no?
This is all Miriam's. Miriam. This is Miriam.
Meron din ba
This is for a one person. Yung kay Cheese. Kay Jingo is also for a one person.
Yes.
No, siya violations naman siya.
Yes, penalties.
Okay.
Meron siya nito.
Alright. Magandang hapon.
Presentation materials.
Magandang hapon po sa ating lahat. We'd like to call this hearing to order. We'll be tackling the following Senate bills. SBN 1636 from Senator Estrada, SBN 1921 from Senator Santiago, SBN 2104 from Senator Escudero, SBN 2175 from Senator Binay, SBN 2194, which is Senator Angaras, and then SBN 2465, which is my bill. The 6 bills actually all have amendments to the Corporation Code, varying subject matters. Actually, there's some which promotes the one-person corporation, another one on penalties, another one, I think Senator Angaras and mine are more of an omnibus type or more extensive. And obviously, this is quite an important endeavor, and we'll be having more than one hearing on this. But we'd just like to get this started already, as was requested by SEC. So we'd like to welcome everyone to this hearing, and we'd like to start by asking SEC to give their presentation. Ms. Herbosa.
Good afternoon, Mr. Chairman. First of all, I'd like to take this to thank you for this opportunity to present or to at least give our position on the proposed amendments to the Corporation Code. Let me first note the presence of majority of the Commission. We can have one in back right now. If possible, we have Commissioner Manny Gaite and Commissioner Antoinette Ibe. And we also have our General Counsel, Milo Correa. Okay, thank you. We just highlighted the major amendments, and this would cover perpetual corporate term, distinguishable corporate name, one-person corporation, and some provisions on how to fast resolve intercorporate disputes and emergency board. And then we have provisions that would strengthen corporate governance among our corporations, including ordinary corporations or even SMEs, and then on tightening the provisions on dissolution. And of course, we have ease of doing business, because I know, Mr. Chairman, you've been always wanting to help our small and medium enterprises in starting a business expeditiously, as what you did when you passed the Go Negosyo Law. And then we have also aligned our provisions on investigations, offenses, and penalties with our other law that we're implementing, which is the Securities Regulation Code. Okay, with respect to perpetual corporate term, right now, of course, the maximum term is only 50 years. We are batting for perpetual existence because this is now the rule in other parts of the world. And perpetual corporations will, of course, mean that the corporate vehicle is a separate and distinct personality from the persons who form it, and it would mean better planning, and would probably also give them opportunities for longer bond issuances that would fund the operations of the company. Although it's not perpetual term, it also means that we would have better monitoring, because we would require them to come to us at least every 25 years, so that would more or less review their operations for the past 25 years and then look forward to their compliance in the next 25 and so on. Now, with respect to corporate name, the reason that we want this change is because presently the stage of registration, when you have to verify whether you can use a name, takes so long because there's always a subjective aspect to it. Instead of saying you do not prohibit names which are confusingly similar, because no computer can determine that, we will just now have a simple provision on distinguishability, meaning as long as the name is not identical to one already previously given to another corporation, then it should be allowed. Of course, with the undertaking that they will have to change it if somebody else who had previously registered a corporation has a better right to such name. Okay, with respect to intercorporate disputes, Mr. Chairman, we would just want to also harmonize the provisions with those in the other ASEAN countries. So notices should be in such manner as to be received. That would allow notices by email or even through other electronic means. Failure to hold elections. There are many corporations, in fact even associations, where they do not hold elections because they cannot muster enough quorum. And so the result is that the present board would always perpetuate itself to continue on as directors. With the provision now, the SEC could itself call the meeting, and even if there's only one person declared as a quorum, and therefore be able to do, for example, have new directors elected by virtue of the quorum that's been declared. Okay, now we go to the one-person corporation. Presently, Mr. Chairman, the law mandates that there should be 5 persons, at least 5 persons to form a corporation. I really don't know what was the source of at least 5 persons, but presently I think there's only about 1 or 2 countries who still have such a minimum. All over the world, they now allow 1-person corporation, 2-person corporation, 3-person corporation, precisely because of the fact that if you use a corporate vehicle, that would limit your liability. And that's also one way of ensuring that people in business, especially SMEs, would be able to comply with our repertorial requirements, such that the public will also be protected. and would know what are the operations of the company, the finances, because they'll have to file financial statements. To us, that's just a small thing to pay for you to do business. Because as opposed to, let us say, single proprietorships where they don't have any reportorial requirements to fulfill, the tendency is always not to, work hard for the business. But if it's going to be a corporation, they know that they can even later on probably distribute the shares of stock among their children or among chosen business associates, then that's good. But Mr. Chairman, as you also mentioned, the other good part about this is that it would eliminate the so-called dummy corporations. And in this world where even the OECD has stressed the importance of transparency of beneficial ownership, allowing persons to form their own corporations without having to contract with somebody to act as the nominee or the dummy, that's really the better practice. However, the one-person corporation would require certain limitations, and this is where we are very open to suggestions, because right now we suggested that maybe there should be a minimum capitalization required, and we have set it at 1 million. We don't know if that would be acceptable, especially if we see that there are a lot of people interested in forming businesses which are small at the start, with probably less capitalization. We're open to changing this proposal. Okay, of course, right now we said that we will allow only one-person corporation per person, because in most jurisdictions in the world, that's also how they do it. But somebody pointed out to us, we've had, by the way, many consultations with the public on our proposed amendments, and they said that what if you want one-person corporation per kind of business? And it's possible that a person may have several businesses and they would want to incorporate each business. So we're also open to whatever the public would want in this aspect. And then also it should be very clear which properties of the person would be part of the capitalization of the corporation, such that his other personal properties, which he probably doesn't want to answer for the debts of that particular business, would not be included in the consideration of which properties are part of the capitalization of the corporation. We've also provided for the so-called emergency board. Again, there are many instances when, because of resignations or illness or probably sometimes death, the board has vacancies, and it could resort to deadlocks. And also now we provided that if there's really an emergency where the board has to decide on something, the board can elect or appoint other members of the board, and only with the prior approval of SEC, the board can then function and do something to prevent irreparable loss or substantial damage. That's only temporary. It's just like something like a mandatory injunction, perhaps, to allow the board to continue in the meantime that there are vacancies in the board. Now, with respect to better corporate governance, we have some provisions that would protect better the rights of shareholders, whether minority or not, and also the role of stakeholders. Presently, the stockholder himself has the right to inspect documents, but that could be an illusory right because he may not understand what documents to get from the corporate record. So now we're saying that that right could also be exercised by his lawyer or representative or even his accountant, and the corporate secretary would be bound to allow such inspection. We also provided that although the laws presently require that intra-corporate disputes be lodged with the regional trial court functioning as a commercial court, and we've noticed that a lot of stockholders don't really like the idea of going to court right away. So we said that perhaps at least the early stage of trying to resolve that dispute should be with the SEC. And we would have some sort of summary procedure that would allow us to settle some of these irritants between or among stockholders. It's not really to oust the commercial courts of jurisdiction. Perhaps if the kind of intra-corporate is one that couldn't really be settled anymore before the SEC, then that's probably the time they should go to the courts. We've also provided, by the way, with the procedure of arbitration. If the stockholders would like to submit it to arbitration, then we can do so under the auspices of the Commission. That would also, of course, be aligned with the present project of the Supreme Court to provide for alternative modes of resolving disputes. With respect to the role of stakeholders, this is also part of good corporate governance. We would require companies to include in their bylaws some ethical practices, or maybe for them to adopt a code of ethics. And that's also something that would put the Philippine companies in competition with the other ASEAN companies, because they're now already having this kind of provisions. Right now, we provided for a provision against reprisal against whistleblowers. We're not encouraging whistleblowers, but we think that if ever the officers or maybe stockholders of companies would like to report on something the company or other directors have done, then they should be protected from being dismissed or being discouraged from talking. With respect to dissolution, because right now, Mr. Chairman, we don't actually penalize the corporation itself. When something criminal is committed, it's always the directors only or the officers responsible. And even the Supreme Court has not really adhered to the universal principle that there's such a thing as corporate criminal liability. We provided that in instances where, for example, the court has said that the corporation itself is liable because all the directors were in cahoots with each other and they, promoted this kind of corruption, let us say, then it could be that the corporate assets should be forfeited in favor of the government. But these are really only for specific violations, like in this instance, graft and corrupt practices, like if they resort to participating in rigged bidding for government contracts, graft and corrupt practices, maybe even acting as dummy for some people who should not be in the business, and then smuggling, money laundering, tax evasion, securities and other fraud, willful falsification, misrepresentation of information in reportorial submissions. We also feel that these provisions would embolden stockholders from voicing out their positions during stockholders' meetings, and they should not be intimidated by the directors and should speak up. So we have other provisions that would strengthen prosecution of offenses and penalties. For example, the companies or the directors and officers involved should be liable for the continued and unjustified use of a former corporate name or the corporate name of another company. There's such a thing also as corporate theft, by the way, Mr. Chairman, so we would be having provisions on that. Concealment of director disqualification. We did add to the grounds that would disqualify a person from becoming a director. If he concealed the fact, let us say that he was convicted in a foreign court, that would be a ground for criminal liability. Violation of the duty to keep or maintain records and allow their inspection reproduction. And also with respect to financial reports, which are very important in keeping business in good order, the knowingly or willfully certifying or giving out incomplete, inaccurate, false, or misleading statements or reports. Other grounds for criminal liability of either the company, the director, or officers involved would be acting or engaging the services of an intermediary for Graft and Corrupt Practices Act, for graft and corrupt practices, tolerating graft and corrupt practices, and retaliation against whistleblowers. All these provisions, Mr. Chairman, we have to admit, we've patterned after those in the Dodd-Frank Act as well as the Sarbanes-Oxley Act. With respect to ease of doing business, presently, if you want to please, although we're going up the competitiveness ranking, we cannot go up so much because there are features in the present corporation code which prevent us from allowing online registration. And online registration is the only way by which you can register a company within 1 day. These are the requirement that the article should be notarized, the requirement that the article should be signed by each and every incorporator, the submission of the treasurer's affidavit. So these are just some of those that we feel we cannot go on full online registration. Maybe partially, like we can already download the forms, we can already have name verification through the computers, but with these proposed amendments, that would give the Commission the leeway to think of how to expedite registration and how to provide for, let us say, electronic means of registration. We also have would request that we be given full discretion to determine which system, electronic or otherwise, that would allow us for the most effective implementation and enforcement of the provisions of the Corporation Code. So those are the major amendments we want to highlight. As I said, Mr. Chairman, we've already, I think, conducted about 10 public fora, workshops on all these proposed amendments. We've gotten encouraging support from the business community, like the Makati Business Club and the Management Association of the Philippines, and also the Sharefield Association, the group of minority stockholders. And we feel that if, take into consideration, of course, the schedule of the legislature, as well as the fact that there are other more urgent bills, perhaps, we feel that we would meet the urgent passage of this bill also.
Thank you.
Mr.
Thank you,
Chair.
Chairperson. But just to clarify, no, on that ease of doing business slide, you do intend to have a one-day registration, no?
Yes, right now we already have 1-day registration to our Green Lane Processing Unit. We provide the forms, they fill it up, and if you file it, let's say, in the morning, you can get it already in the afternoon, but if you file it in the afternoon, it's going to be the next day.
But you would need the notary, the treasurer certificate.
Still,
dala-dala mo
yes.
na yun when you,
Yes, yes, when they come. And we've seen how they do it in Singapore. It's completely online.
And how do they get around those requirements?
They don't have such requirements.
Do we need those requirements?
Actually, if you want, please, I don't think we need those requirements, because notarization is really just to what? Do away with evidence when you go to court and prove the veracity of the signatures there.
Saka sa kanto ng Santolan, maraming notaryo yun, di ba?
Hindi lang po yun, Mr.
200.
Chairman. It's actually like trying to protect or trying to foresee that about 10% would do something bad. But for 90%, they're all in good faith. They really do, they present their correct teens, they put their real names, these are all adults. Sometimes we have cases like somebody would put in the name of their child, and it's a minor child. So there would be fraud in
But those are aberrations, no?
Yes,
not
only
really
less than 10%. Your Honor.
Okay. If I'm not mistaken, we filed the version that you suggested to us, no? So I take it that that's the version that you
Yes.
are pushing for, no?
Exactly.
I think Senator Angara's and my version are quite similar. Tama, Attorney, no? And then the other bills are already encased in the longer bills, no? So,
We did a matrix, Mr. Chairman.
can you use the mic, please, for the record?
Upon the request of your staff, Mr. Chairman, we did a matrix of all these pending bills on amendments to the Corp Code, and I think it's been provided to your staff. If not to,
Yeah.
if it does not reach the chair, then
Yeah. So for the
Just
record,
inform
it's either the Angara or the Aquino bills are the ones which are you're most supportive of, no?
yes, Mr. Chairman. And so, because these are the bills which are in harmony with each other.
Okay. All right. Do you have a comment from BSP, and then from the Insurance Commission, then from DTI?
Yes,
sir.
Mr. Chairman. The BSP took a look at all the Senate bills filed, and in general, the Bangko Sentral ng Pilipinas supports the proposal seeking to amend the Corporation Code, knowing very well that this will make it more attuned to the recent developments in the way corporations do their business. Some of the proposed amendments are intended to strengthen governance in corporations, while the other proposals also focus on making the Securities Exchange Commission a more responsive regulator of corporations. However, we have some specific, on the specific proposed amendments, we have several comments. Right now, the status is we have pan it out to the different sectors of Bangko Sentral. Their comments are in, we are now harmonizing some of their comments. The comments generally pertains to some of the operational aspect on how this corporation will affect our supervised institutions like banks, as well as the implications on current regulatory issuances. So right now we are now harmonizing it. Last December 10, we requested the Senate to give us an extension to give the final position paper. It was received December 15. So we are now in the process of finalizing it. We will submit the position paper. We have a lot of comments on focusing on how we will going to operationalize some of these provisions as far as bank supervised
Of course.
institutes concerned.
Mr. Cruz,
Yes.
can we get those comments by January? Or are you looking at February?
By January, because it's
By January.
almost in. We're just trying to consolidate and harmonize some of the comments.
Siguro po
Some of
what
the comments are not.
major.
Some are major comments, but this difference in opinion how to interpret some of the
Okay.
provisions.
I would suggest so that once you submit your comments, we convene informal TWG for the SEC to
Yeah.
also look at the comments and see how they can harmonize
Yes, Mr. Chairman, yeah.
the issues.
We'll do that.
Of course, we value the BSP's comments on this matter.
Yes,
Thank you.
Mr. Chairman.
So January, sir, wag
Yeah.
naman February.
January.
January po. Kahit second half of January, wag naman yung January 5, di ba? Mga after the Pope's visit. Sige po, okay na po yan, no? SEC, okay na. Yes, Attorney Castro.
Good afternoon, Mr. Chairman. Insurance Commissioner Emmanuel F. Toc sends his apologies for not making it in today's hearing. As far as the Insurance Commission is concerned, we have yet to file our comments or position paper to the proposed amendments to the Corporation Code because we are still awaiting for the comments from our regulated industry, sir.
Are you okay also with the January deadline?
Best effort, sir.
Nako. Hindi matutuwa si Chairman Herbosa niyan. Because they're really pushing that this bill gets passed. And alam mo, next year, election fever will take over by the second half. So the window to really pass things is until about June or July. So, and this is quite a lengthy bill. So I endeavor, or I hope you will endeavor to pass it by the second week of January.
Yes, Mr.
After the
Chairman.
Pope nga.
After the Pope
Oh,
visit.
sige.
Thank you,
Yan po.
Mr. Chairman.
Attorney Cabradilla.
Thank you, Mr. Chair. BOI, with its mandate to promote and facilitate investments, generally support a legislative measure that would promote the ease of doing business in the Philippines and improve the business environment in our country. Thus, we welcome the proposed amendments of the Corporation Code. Now, as for our official position paper, we'll be submitting it as soon as possible also.
Ano rin, after the Pope na rin, ha? Okay. Gandang deadline, ano? Would the panel want to comment? What other agencies would be important for us to get comments on? So we can make sure that all in na tayo when we have our next hearing. Any other? Can you imagine any suggestions for more commissions or institutions that we would need to speak to?
If you want, please, I'm glad that the BSP, the IC, and the BOI are here because precisely the Corporation Code now requires us also to wait for the endorsement of the primary regulator whenever certain companies would register with us. For example, if a bank wants to incorporate, they will first get an endorsement from the BSP. If an insurance company would like to incorporate, then they'll have to get the endorsement from the Insurance Commission. That's fine with us because they're also very fast in doing that. But the problem is that's counted by the World Bank as 1 day. So if you're going to have electronic connectivity with all of them, then we can do it electronically. That will be faster. Maybe that will be counted as 1 day. But we are not changing that requirement. We just want to also, because especially with respect to schools, of course the Department of Education, with respect to mining companies, we are asking the Bureau of Mines or the DNR to give us. Some regulators sometimes say they don't want to give, or they're just leaving it to us.
Or ano, ma'am?
I don't know what.
Siguro if SEC can give us that list of those regulators or agencies that need prior approval or are in the process, the committee can be the one to write them para mabilis po tayo, no? But we would need to have that information probably by January 5, no? So we can start sending them letters. But definitely for schools, so DepEd, CHED, DOH rin, no? DOH. But these are probably a smaller percentage of the companies that incorporate, di ba? Kasi special sila, may regulator sila.
In fact, Mr. Chairman, the green lane, that goes for those that don't need endorsement. It's over 60 to 70% of it.
Okay, okay.
For the endorsement, plus the more complicated ones, with
Mhm.
very complicated primary purposes, would make up the non-one day.
Okay.
I mean, usually a week, maybe at most.
Okay, so we'll wait for that list, no? And we'll ask them to also provide position papers. Then for BSP, Insurance Commission, and BOI, we hope you can submit by January 20. Tama, di ba? January 20. So that we can have our next hearing probably first week of February or end of January. And hopefully by then, we can already present a consolidated report. I'm hoping that the suggestions from the other regulators or other agencies can be incorporated in this bill if there are any ones, and we can just tackle in the TWG if there are any conflicting provisions, no? But I would think, I'm hoping there aren't, no? Because ano naman to in principle, I think the principles are okay, no? It's really in the specificity of the regulation, no, that we need to look at, which is also their mandate, no? Okay, is there anyone else who wants to give a comment or share anything from the crowd? Okay, kung wala, Merry Christmas. Thank you for this hearing, and we'll see your position papers first before we see you, but we'll see you come end of January or early February. No? This hearing is suspended. Thank you.